A False Claims Act Qui Tam lawsuit has to be brought initially under seal. And that's not just a normal seal that you file something electronically with the court. It actually has to be filed in camera, meaning you file a paper copy of the complaint and you give it to the clerk or whomever is going to be receiving it, and it's never posted, or it's not posted at that time to the publicly available dockets. So that's one of the main requirements. I mean, that's an upfront first order requirement. Also, that claim, that complaint, along with all of the information that the relator has to be submitted to the government. And the way that's generally done is by submitting that information to the Department of Justice, the Attorney General, and in the state context, the State Attorney General. That's, again, a must. You have to do that in order to be able to recover anything under a Qui Tam lawsuit. So once you've filed your claim under seal and you've submitted the information to the government then has to look at the case. Because really what you're doing as a False Claims Act relator in a Qui Tam lawsuit is you are the government. And so you have to give the government an opportunity to decide whether or not they're going to pursue your claim. And that's called intervention. So you essentially give the government a period of time, and since they're the government, they can take oftentimes as long as they want to decide whether or not they're going to intervene in your claim, whether or not they are going to take over the prosecution of this Qui Tam action. That decision by the government on whether or not to intervene for years was almost determinative of a False Claims Act claim. That's become less the case now, but it's still a very important piece of any Qui Tam claim. The statistics are grossly out of whack when it comes to these types of claims as far as intervention. In other words, claims in which the government intervenes on oftentimes settle or a judgment is rendered in the government's favor on about 85% of those cases. I mean, so it's a very high amount of cases that are successful once the government intervenes. On the other hand, those cases where the government doesn't intervene, it's almost the exact opposite, if not a little bit less. In other words, 15% or less of those cases result in a positive outcome and result in some sort of recovery. Meaning that if the government doesn't intervene, a relator's chances of a successful lawsuit oftentimes drop dramatically. Whether that's right or not is kind of beside the point, because it's a very risk-based analysis that relators and counsel like myself for relators engage in. So if the government intervenes, or if the relator is able to pursue the claim themselves, the lawsuit eventually, the complaint eventually becomes unsealed, meaning that it's publicly available, and now you're essentially in a normal lawsuit. You go through discovery, you go through motions practice, just like you would in any other lawsuit. The key with False Claims Act cases is really that first step, though. After the claim is unsealed, the first thing that you're always going to see is a motion to dismiss from the defendant. And that's because these claims are very intricate and require a lot of specificity in their pleading. So oftentimes defendants are able to get out of these cases because the attorney or the relator or sometimes the government has made a mistake or has failed to plead the claim in the proper way. And so right off the bat, defendants are oftentimes able to get out of these cases. And so that piece, that motion to dismiss phase, is oftentimes one of the most stressful and most important pieces of a Qui Tam lawsuit. After you get over that, after you get past the motions to dismiss, you then get to engage in regular discovery. You get to confront this oftentimes corporate entity about their wrongdoing. You get to dig into their records and you get to prove their fraud. And that's very exciting and it's very rewarding. But it's also a very time-consuming and difficult process, not only from an attorney's perspective, but even more so from the relator's perspective.